It's not in the face! Thank you.
Hello and welcome to Hey, Not the Face with your host, John Nash, and your producer, me, Steffi Haynes. And yes, you are getting a second episode this week because our antitrust primer series is here to get you up to speed before this trial hits on April 15th. So today we're going to look at the possible impacts from this case for the fighters, for the fans, and even for the UFC. But first, we got to check in with John and see how he's doing on this fine Monday afternoon.
Tired, exhausted. 2 episodes in 1 week, that's too much. I can't handle this workload.
And Miss Isla, where is she in this?
She is asleep in my closet. She likes to go in there during the day sometimes. But I'm sure she'll make an appearance at some time. If she knows I'm doing something, anything, she has to check it out, make sure she's a part of it. So I'm sure at some point she will be making an appearance.
You have yet to acquaint yourself with this fully because you're still in your first year of ownership with Isla. But listen, that is called kitty quality control. That's what they do. They inspect, they make sure that you're doing everything properly.
Well, first I got to correct you there. There's no me owning her. This was thrust upon me, and she basically controls me. She dictates everything. I had no say in the matter.
And that is generally the rule of thumb for all cat owners. I'm glad it's happened to you, though. See, now I'm no longer alone in this.
Yeah, I'm just a pathetic cat parent in Hollywood. I've entered that club.
You're a fur parent, a pet parent.
Yeah,
oh my goodness.
Yeah, no, I can't believe we just wasted this much time talking about the cats.
So listen, before we get started on this antitrust primer, I have a quick question about something with PFL, if that's cool with you. Because I saw this tweet by Alexander Shabili that basically, or Chablis, excuse me, where he says that PFL is no longer paying the winner of his upcoming bout with Usman Nurmagomedov the $1 million prize that was originally promised to the Bellator Grand Prix winner. Now, can they do that? Is that legit? Is that legal? How does that work?
Well, we'd have to look at any sort of agreements they might have signed. There might not be any, and I'll reach out and try to find out what the original agreement was that was offered by Bellator. If it's concrete in the contract, the terms that they have specific terms, and for various reasons, the Bellator, the Grand Prix ends and there's no prize, then yeah, he wouldn't have a case. But if this is more of a verbal agreement, my understanding was it wasn't like there was an actual contract signed for these Grand Prix. It was pitched to the fighters and they agreed to be in it, and there was a promise of $1 million. Well, now you enter the world that they've made a verbal promise. There's an implied contract and verbal contract there. He would have a very strong case to go, him or Usman, to go forward and take them to court. Even before the fight, to say, yes, we were it was an implied contract that the winner of this Grand Prix, this tournament that we entered specifically with this prize at the end, that's why we signed up. It's a verbal or an implied contract, and he would have a case. In fact, if people notice the tweet when he did this originally, there's a guy popped up and quote tweeted it, and that guy is Rob Macy, I believe it was, or the MMAFA account, one of the two, saying we are easy to find. That seems to suggest that at least Macy, and people aren't familiar, Rob Macy is the attorney that started this whole antitrust lawsuit. He thinks there's a potential case there. So That would imply that there's probably a potential case there.
Well, good for them. You know, I love holding these promoters' feet to the fire whenever they step out of line. I love this. I hope we see more of this. But for now, we're going to see more of this primer. So let's get started with that. Let's look at what's at stake with this antitrust suit. First, how will it impact the fighters? Like, which fighters are members of the bout class, which was, if we recall back to our last episode, the bout class is the class that was granted certification.
Yeah, so I'm going to read the description of the bout class so people know. For this, the Lee versus Zuffa case, the bout class is defined as all persons who competed in one or more live professional UFC promoted MMA bouts taking place or broadcast in the United States from December 16, 2010 to June 30th, 2017. The bout class excludes all persons who are not residents or citizens of the United States unless the UFC paid such persons for competing in a bout fought in the United States. So under that definition, really the first sentence definition, all people who competed in one or more live professional UFC promoted MMA bouts, that covers over 1,200 fighters fit that definition between December 16, 2010, June 30th, 2017. I think the question is, how many of those fighters are potentially non-U.S. citizens or non-residents of the U.S. that fought outside the U.S.? And so there is probably a percentage. I don't think it's a huge percentage, but maybe 20, maybe that 1,215 fighters gets knocked down to 1,000 if you exclude all those other fighters. So that's the part that I think a lot of people miss. It includes everybody that fought in the UFC during that period, but it excludes non-citizens that fought outside the U.S. or non-residents too. Because if you have, a lot of foreign fighters have green cards and reside in the U.S., they would be eligible for damages.
That seems to create a murky situation, though, wouldn't you say?
It does create, a little bit murky, but the U.S. jurisdiction doesn't go everywhere. But it does. I guess there is a lot of fighters, I think, that are questioning. I'm sure a lot of overseas fighters are curious if they qualify, because someone probably came to the UFC on a visa, but not an official resident. So they might not qualify. They didn't fight in the U.S. But the most obvious, if you fought in the United States on a fight, you get damages. If you're an American citizen, no matter where you fought, you get damages. If you're a U.S. resident at the time, you get damages if they win the case. So that's the group. So for those fighters, you're clear. The ones that might have some questions is, if they fought if they're the prelim fighters, let's say on like an UK card or Ireland, a lot of those fighters, if you look at it, they have 2 or 3 UFC fights and they never fought outside of their native country.
Yeah.
Or native region. So those fighters, unless they were residents of the U.S. because they were training in the U.S. or for some other reason, they're not eligible for damages.
And again, seems beyond murky, seems a little messed up because they were underpaid too. So my question would be, and this might not be something we can answer immediately, I don't know, but my question would be, what about those guys? Is there any recourse for them maybe in their own country? How do they get compensated when they were also underpaid? Undervalued.
Well, that's where it's going to be a problem, because they could potentially take action in their own country, but it's going to be very hard to prove damages for the prelim fighters, right? The hard part is, how do you prove damages when you don't have what they call the headliners? The whole model of this lawsuit is based a lot on the headliners, the guys that the top 15 ranked fighters that they say drive attention and revenue. And the UFC, foreclosed, they say, on the top fighters. So they had the high percentage of them. That's where I think it's going to be a problem, because even if they win, what method are you going to, you're only going to be a few fighters, just a handful in your home country. You can't really file the same as a class action. You could ask your domestic country to, the EU has antitrust laws. You could have them look into the US, but I really don't think there's any way for those fighters to really take the UFC to court over this, because again, we're talking about handfuls of fighters in different regions who, it sounds mean, but they're really at the bottom of the card. And because it's the bottom of the card, it's going to be really hard to prove any damages to them.
So if the fighters win in the trial, what are the damages they could be awarded? And further, how was the amount determined?
Well, I think we've talked about this before. The the plaintiffs experts came up with a couple of yardsticks methods, right? And one of the methods they use what they called the Bellator yardstick, and that was that the fighter should have got like 44.5% of the revenue, some in that ballpark, around 44%. The others, they use the Strikeforce yardstick, which was 63%. And so they use various yardsticks of what the fighters should have got paid. Now, the fighters overall got paid about under 20%, like 18% of the revenue. About $650 million, if I remember correctly, is what the actual payment to the fighters. So the difference between what the fighters got and what they would have got under the yardsticks is the damages they're claiming. So the low end, it'd be $811 million. That's the low end of damages. The high end of damages under the Strikeforce yardstick could be a little tiny bit over $1.6 billion. That's the total amount. Now, we got to remind people this is an antitrust case. So if you win it in a jury trial, which this is a jury trial, the damages are trebled. So they get tripled. So that 811 becomes 2.433 billion, billion with a B, and the other one becomes almost $5 billion.
How would that be divided amongst the fighters?
Now, there's been some question about this. So one is that the regression model would be used, which is the formula that they use to determine how much the damages were, how much fighters were underpaid. An example is they list some of the underpayments to the named plaintiffs. And one of them, I think, was John Fitch. And under the high end, it was $2.5 million. He was not underpaid. So he was owed $2.5 million under that model. But if you listen to a recent hearing, a few months back, Eric Kramer, the lead attorney for the plaintiffs, talked about the methods that most likely be used to compensate fighters if there's a decision for them. And the two most is one is basically per capita, just divided up by the number of fighters. He struck that down because he just didn't think it was a doable system to pay everybody the same amount because they fit in different categories inside the class. The other way to pay everybody would be a pro rata, which in other words, that the amount of money, the percentage of the compensation the UFC paid out would be your portion of the damages. So let's say the UFC paid $650 million, I think we said, in total compensation. And let's say the court awarded the fighters $1.3 billion twice what that compensation is, then all you would have to do to figure out what a fighter's share of the damages would be is take how much they were paid during that class period. If a fighter fought 4 times at $30,000 a fight, made $120,000, well, then he would get $240,000 in damages. If a fighter fought 10 times and made $500,000 during that class period, he would get $1 million in this scenario. So that's the simplest way. So that seems like the method they're going to use. They've suggested it. So the way to look at it is the percent, what the relationship of the damages to what the total compensation will be the relationship to when will be used to take the fighter's total pay during the class period and multiply it against that. And that'll be his damages.
How much would the attorneys get then?
Okay, well, this is the next part. You'd have to cover the attorney costs. The court could order the defendants to cover some if the plaintiffs win, because you are allowed to ask for attorney fees in an antitrust case. If you're a plaintiff, you can ask the defendants to cover your attorney's fees, and in these cases, antitrust. So if the attorneys are not covered, right, by the plaintiffs, by the defendants. What this system, they haven't said it officially, but it's been suggested that they're using the lodestar method. And what the lodestar method is that the attorneys, they take their hours and then it's multiplied. They gather all the hours they worked, and there's a multiplier that's given by the judge based on how well they actually did in the case. In other words, what the damages they got awarded are. So usually, if you look at it, the percentage comes out about 20% of the total amount awarded under Lodestar on average goes to the attorneys, which it basically means you're paying them almost like that's your manager or agent in MMA. So that would be their fee. Now it can fluctuate. And one thing too, if the judge doesn't have a high multiplier, but there's huge damages, that percentage is going to decrease. And if the damages aren't really high, but he gives them a higher lodestar multiplier, the percentage would increase. But on average, looking through cases, it seems to come about 20%.
Okay, I want to go back to injunctive relief again. Remind me why this isn't on the table and why this case can't change how the UFC does business, this particular case, Kung Lee versus Zuffa.
Yeah, well, that's something that I notice a lot of fans and readers get kind of worked up about, that there's no injunctive relief on this case, because I think they understand without injunctive relief, money alone is not going to change the UFC's business, because the UFC makes so much money now, right? I mean, it just makes ungodly amount of money. So even if you get a high damages against them, they're just going to take a loan out, another loan. They already got over $2 billion in loans that they can cover, and pay for it with their revenue, which they gain by paying the fighters very little. There's no incentive or nothing compelling them to change their behavior besides the fear of more damages. And we'll probably talk about that later. That seems unlikely to be fear of more damages in the future with them. So injunctive relief was the tool, and that everybody kind of hanged their hats on that may cause some change in this case. I guess the other thing, the damages would have been a bigger deal if this case had worked faster through the system. But ever since they got that ESPN deal and profit margins have skyrocketed, no longer are like I said, the threat of money that is as scary as it was before. The Lee v. Zuffa case ends June 30th, 2017. And there's such great distance between when that ended and now. A second class, a period of class members appeared, and that class was the Johnson v. Zuffa class that starts up on July 1st, 2017. Okay, so now because there's such a great distance between when Lee and there's this new class that the Johnson case covers, and the UFC changed their contracts right around 2017. Which is why, Francis Ngannou was able to get out of his contract. Because of all those, the Lee class no longer represents current fighters. And because they don't represent current fighters, they don't have standing to force injunctive relief on the current behavior of the UFC. It has to be investigated again and through discovery and analyzed again. And that would be the Johnson class that would have that the court would give the power, the authority over any sort of injunctive relief. And so the attorneys, instead of wanting to delay this even further to merge the two for injunctive relief, they said, we're just going to go ahead for damages, and injunctive relief will be decided exclusively in the next class action, which is the Johnson class, which is only in the very beginning phases.
Let's talk about the class action waiver. What is that and what does it mean?
Well, we know that the UFC changed their contracts with Francis Ngannou period, about 2017. Then a few years after that, only recently, probably in, I guess, the last 2 years or so, I've noticed in contracts, they introduced a class action waiver and an arbitration clause. The arbitration clause says if you have any problems with the contract, you don't go to court, you go to an arbitrator. The class action waiver says you cannot participate in a class action. And so fighters now that sign those new contracts cannot take part in a class action. Now they can't, this doesn't exclude them if they've been around for a while from the Lee v. Zuffa case, because that case was already been class certified, already been moved. It's been going for a while, or I guess they'd already been asking for class certification. So you can't you can't retroactively say you have to be excluded from a class action that's already ongoing. But at the time they introduced this, the Johnson class hadn't made any progress. So fighters that have signed those class action waivers can't take part and be members of the Johnson v. Zuffa class action if it ever gets certified as a class action. And so that means that all those fighters, even if they fought from 2017 until today, if they signed at some point the newer contract, they are excluded. So if Johnson case goes ahead and wins damages in a trial or a settlement or whatever, those fighters are excluded. They're not a member of the class. They get no damages in the future. And there's I have a theory, and one of it, remember after the UFC Endeavor bought the UFC, we had a period where people were shocked at who was allowed to remain in the UFC, no matter how many losses they had.
Mm-hmm.
it seems conceivable to me that one of the reasons they didn't cut people is because they had the old contract and they were letting them hang on and sign new contracts until they introduced and could sign the class action waiver contract. Can't prove it, but that seems like seems like a possibility, because you let them hang on, you let them sign the new class action waiver, and now you don't have to worry about, you're removing huge numbers of fighters from that being potentially members of that class that you would have to pay if you ever lost in the class action a class action lawsuit. The other thing, this class action waiver, because everybody now signs it going forward, the UFC really has no threat of future class actions. These two are basically it right now. After this, every fighter that fights for them is going to sign a class action waiver. They're not concerned about class actions, which probably explains why a few years after they introduced those changes in 2017, Ngannou gets up and uses the 5-year sunset, that they have now made these contracts much more restrictive than they were before.
And they lengthened that sunset clause considerably, correct?
Well, they didn't. It still says 5 years, but they put a lot of loopholes that let them extend it well beyond those 5 years.
Right. So let's talk about how the injunctive relief that's on the table for the Johnson case could impact the fighters.
A lot.
But you got to break that down.
Well, it's the injunctive relief still could impact the fighters, even though they signed a class action waiver. First of all, the judge, not a jury, determines injunctive relief, right? So it's the judge that makes that determination. So even though all these fighters signed waivers and they're not affected by the jury decision of damages, if the plaintiffs bring forward a case and it goes to trial and they win, the judge could order injunctive relief, could even apply to those that signed the class action waiver. And so injunctive relief for Johnson, for Lee, it doesn't mean much because there is no injunctive relief. But several years from now, if the Johnson case works its way through the courts and there is injunctive relief, and they win the trial and the judge orders injunctive relief, it could have a massive impact on the industry because they've hinted what the plaintiffs are asking the judge to do. Now, the plaintiffs would, they make suggestions, and it'd be the judge's power to make the final determination how I should apply injunctive relief to fix the industry, to heal this industry. That's been, this market that's no longer competitive. And what the plaintiffs have asked for, they did it in hearing, they've done it in a couple filings, is basically say the contract should be no more than 1 or 2 years maximum with no extensions whatsoever. And if the judge followed that suggestion and ordered that, that would drastically change the industry, because fighters would no longer be signed into long-term contracts. They'd be free agents every year or two. And if they did that, you would see promotions possibly springing up. Look at PFL is basically begging UFC fighters to test the market, right? Well, they wouldn't have to wait that long, and fighters wouldn't be signed to long-term agreements. They could just hold out money and see who would be willing to try it now, especially the name guys. So it would be a radically different market, and fighters would find themselves with a lot more options, a lot more leverage. It's not coincidence that every time the closer Ngannou got to being a free agent, right, the more the UFC was offering him, because they knew they had to entice him. Now, if they can extend your contract forever, you never get to that part where the UFC gets nervous that they're going to leave, so they don't have to offer as much. But if they're convinced that every step that you're getting closer and closer to leaving the promotion, they might offer more and more to make sure you stay.
And we might actually see some cross promotion too, right?
Well, nothing orders that we might not see cross promotion.
But you would think that if the contracts are only 1 or 2 years and they really want to lock in some big super fights, they might entertain the idea.
They might. Especially with the biggest guys, might have the power to force some sort of cross promotion. Definitely on that end. But it's not 100% certain, because the UFC has such a strong position in the market that even then they might refuse to. But other promotions, you have PFL right now, but there's so many fighters are available. Another promotion could pop up in those guys, because there'd be such cross-pollination all the time, back and forth, because fighters' contracts, if the UFC is the industry leader is only offering 1 or 2 year contracts, it's going to be harder for the other promotions to offer, oh, we want you to sign the typical perpetual contract when the UFCs are so short.
Yeah. Man, it's a catch-22 all the time, isn't it?
Yeah, it is. But I mean, I think in the end, it would force the other promotions to offer much, much better contracts.
So if there is a settlement, how does that work? And does the settlement work for both cases? Is there a different settlement option for the Johnson case? Or are their damages going to be different? Are they intertwined? This is where it gets a little hazy.
Yeah, if there is a settlement, they could settle just the Lee case right now and then continue with Johnson as a trial. But you would think if injunctive relief is the major threat, right, you would think that any settlement now, if they settle Lee, they would want to include Johnson. And so they would talk to the Johnson named plaintiffs and the attorneys there and work on something to settle both cases, because that would eliminate the threat of injunctive relief in the future. Now, one thing is, it probably wouldn't cost a lot in damages because I said that class action waiver, the Johnson case is not going to have nearly, even though their model when they're done might show that the fighters were underpaid much more money than this current crop because the UFC made a lot more money, right? The amount of damages that could possibly be awarded the fighters is going to be very small because so many of them have signed waivers. I mean, I just at the top of my head, I can only think of a couple big name fighters that probably haven't signed waivers that fought in that period. That's one fight by George St. Pierre. He did that. Conor McGregor possibly, because he hasn't signed a new contract to best of my knowledge, so he might not have the class action waiver. So you're talking like a handful of fighters, but the vast majority have signed that waiver, so the damages wouldn't be that high. So they could work on injunctive relief. The thing is, if you negotiate injunctive relief and the court doesn't order it, I don't see the UFC caving in and saying we're going to grant you a change of our contracts as part of the settlement that's anything close to like a 1 year or two. That's disaster for the UFC. That's something where the judge just lowers the hammer. So injunctive relief on a settlement would probably be much more along the lines. I think the UFC's offer would be much closer to what the changes they made in the Ngannou period. And the plaintiffs might ask to go a little farther and said, I'm just going to throw something out there. And so before the UFC said we have 5-year sunsets that start when you sign, maybe the plaintiffs go, you get that down to 4 years and we have an agreement. So you would have some change to the contracts. I just don't imagine them being the massive changes that the industry, investors, and TKO were worried about with injunctive relief being ordered by the judge.
All right. So for you subscribers, stick around because we have some bonus content coming up. And if you're not a subscriber, you kind of know what to do here. Hit the subscribe button. Help us out. Help us keep bringing you this content. To access the bonus content of this episode, you must be a paid subscriber. To do that, go to heynottheface.substack.com and subscribe today.
Ow! Ow! Not the face! Ooh! Ooh! Okay, the face!